Hello, everyone. So I'm Jordan Becker, and I'm a patent attorney, an IP attorney, and I do tend to focus on patents. And today we're going to talk about the top IP mistakes that could derail your startup company. And a lot of these mistakes are also applicable to more mature companies, but I tailor these topics to be the ones that are most relevant to startup companies. With that, let's dive right in. Um, right, so obligatory disclaimer here because I'm a lawyer, but I'm not your lawyer to anyone listening to this or viewing this. And nothing in this presentation is legal advice. This presentation is purely for educational purposes, and any opinions expressed in this presentation are only mine and not those of my law firm. So with that being said, I also want to mention that if you have any questions, we're going to have roughly 45 minutes worth of material to present, and then I'll address questions. So please put your questions in the Q&A feature, not in the chat, and I'll address those, excuse me, at the end. All right, so first, you may be thinking, who the heck is this guy? All right, so a little bit about myself. I have a Bachelor of Science in Electrical Engineering from the University of Connecticut a long time ago. After college, I worked for 4 years as a rocket scientist for McDonnell Douglas Space Systems in Southern California. I was working on the Delta II launch vehicle, and then went to law school at Pepperdine University in LA. So that was 30 years ago. I've been practicing IP law that long, based in Silicon Valley. But my practice is a global practice. Most forms of intellectual property are at least federal in nature. So I can be sitting in any state or actually in any country and practice US patent law at least, and most aspects of IP law. So what I focus on is developing and implementing IP protection strategies for companies that are based on their business strategies and tailored to their business strategies. And I focus on technology companies primarily. So I don't do really any drug-related work, pharmaceutical work, although I have colleagues who I work with closely on that type of subject matter. What I work on is patenting primarily software, electromechanical devices, and optics. And so some of the areas where I have a lot of experience are AI, cybersecurity. Obviously, those two can overlap. Medical devices, wireless communications, and AR, VR, XR, among other things. I've pretty much touched every kind of technology over the course of my career. So with that being said, that's enough about me. Let's get into the substance. All right, so we're going to talk about mistakes people make. Mistake number one, and let me address the elephant in the room. I'll just let that sink in. Right, so mistake number one is thinking that software isn't patentable. Yeah, it is. I can't count how many people seem to have this misconception even now. And what this stems from is really history. And at least generally software is patentable, although certain kinds of software can be difficult to patent. And I'll get to that in a moment. But the reason there's this myth that software isn't patentable is that back in the 1960s, that actually was the case. The patent office had a pretty clear position that wasn't addressed in the law. It was the patent office policy in the 60s. And so patent attorneys had to be clever and frame software-related inventions. Of course, software was pretty early and primitive back then, but to the extent software existed, they would frame them as hardware for the 60s and 70s and into the 80s. But starting in the 1980s, we saw court decisions come out that slowly started to make clear that, yes, indeed, software is patentable. Then in 2014, we had a Supreme Court decision come out that really messed things up. It didn't say software is not patentable, but it held, in a particular case, it held software to be unpatentable that has set some precedent that made it difficult to patent certain kinds of software, particularly software that is very business oriented. In other words, solving a business problem as opposed to a technical problem. So the bottom line is, if your software is solving a technical problem, it's usually not going to be a problem to patent it as long as it meets all the other requirements of getting a patent, which is it has to be novel, has to be non-obvious, okay? So the case I'm talking about is the Alice v. CLS case, and it dealt with what kinds of subject matter can be patented and what cannot be patented. And the case came out and said that if your software is too or rather, if your claim is too abstract, you will not be able to patent it. And it seems that business-like software, for example, using a computer system as an intermediary for some sort of financial transaction, that's kind of using a computer to do something that human beings have been doing for a long time. So that kind of thing is going to be more difficult to patent than software that's solving a technical problem like optimizing memory usage or optimizing bandwidth or making a processor work faster or compressing video more efficiently. Those are technical problems, easier to patent than non-technical problems. Okay, so that's mistake number one. So just to recap, software is patentable in general, although certain kinds of software are more difficult to patent. Okay, mistake number two, thinking that copyright is enough to protect your software. Okay, now I put these mistakes in quotes because this is the fallacy, okay? So this is kind of the opposite. Hopefully you're all picking up on this, kind of the opposite of what is true, right? So the thing to understand about copyright is its very narrow protection. Copyright only protects the specific expression of an idea. Now, when that comes to software, that really means the code itself or very, very minor variations from the code. And copyright can apply to a lot of things. I mean, I think pretty much everyone understands it. It applies to the written word. It can apply to a public performance, music, sculpture, but for our purposes, I think most of us are focused on technology, and in the technology realm, software is really the area where copyright comes into play. So it's very narrow protection as opposed to patent protection. Patent can protect an invention. In fact, that's precisely what it does, is it protects an invention, and the invention can be defined much more broadly than the actual code. And so that's why patent protection is typically stronger than copyright protection. Another reason that copyright protection alone may not be adequate is there is no such thing as innocent infringement of copyright. In other words, the alleged infringer has to actually have access to the code to copy it, whereas a patent can be innocently infringed. And that's a good thing if you are the patent owner. That you can go after someone that doesn't have knowledge of the patent. It's a powerful tool. All right, so that's mistake number two. All right, mistake number three is thinking that I don't need a patent on my invention because I don't plan to sue anyone. I also hear this a lot. Well, the thing to understand about patents is that the ability to sue someone is only one of a number of reasons why you might want to have a patent and why a patent can be valuable. Okay, so that's what I would call the obvious offensive use of a patent, is the ability to sue someone or potentially collect licensing royalties. But there are other uses which I would categorize as defensive uses or building the business uses. So defensive uses, for example, having a patent is deterrence against other operating companies that may want to assert their own IP against you as a founder of a startup company, for example. It's also a bargaining chip to be used, or that can be used in negotiation with your competitors. And also among defensive uses, I would say blocking competitors from getting their own patents. And the reason is because once a patent is granted, or in fact, once a patent application gets published, it becomes part of the prior art. Now, prior art is a term that we patent attorneys use to describe all of the public knowledge that predates your invention. And so that actually determines whether you or anyone else can get a patent on something, is what is in the prior art. So when you get a patent or when your patent application gets published, that then potentially blocks your competitors from getting patents on the same or maybe similar subject matter. All right, so now let's go to other reasons you might want to get a patent. Building the business uses, okay? So for one thing, patents build investor confidence. And in fact, as a startup company, most sophisticated investors are going to expect and require that you have taken steps to patent your invention if you work in the technology space or in the pharma space for that matter. Perhaps very early stage investors, friends and family, angel investors may not always require that, although many will. They may not do ask a lot of questions about what you've done. But when you start getting into the later stages of fundraising as a startup company, particularly the venture funding rounds, venture capitalists are almost always going to expect that you have at least filed a provisional patent application. Depending upon how mature your company is, they may expect that you have actually filed a number of patent applications and even have some granted patents by that point in time. So that's another reason. And the patents and other IP factor into the valuation of the company for purposes of fundraising. Patents also help build customer confidence. When you say you've got patented technology, that's a good selling point for your products or services. And they also help enhance the company's reputation as an innovator. So, last but not least, I think patents tend to build employee morale as well. If you can, when you put the plaques up on the wall, so to speak, it's good for employee morale. All right, mistake number 4 is thinking that once I have a patent, I'm free to make or sell my product without concern. No, and here's why. People make the mistake of assuming that because they have a patent, that gives them the right to actually make, use, or sell their product. A patent only gives you the right to stop somebody else from making, using, or selling your product, or the patented invention, I should say, or importing the patented invention. It doesn't give the patent owner the right to do it. That confuses a lot of people. A lot of people think that doesn't quite make sense. Let me try to explain that visually. Okay, these red circles are, let's say, the prior art that's out there before you come up with your invention. It's the sum of these red circles are the state of the art. Now you come up with an invention, or let's say you come up with a product idea, and it's a novel product idea. So that's the green circle in the middle. And then you then go to your patent attorney and say, hey, I want to patent this. And you're lucky enough to find a really good patent attorney. And he or she then defines your patent much more broadly than your actual product implementation. So here's the idea, is to expand the scope of coverage, which is the lighter green circle, right up to the point where it just bumps up against the prior art, but doesn't actually overlap it. That's what you want, okay? That's the strength of a patent, okay? Now, here's, and this is not what you want. This overlapping of the prior art, that gets you an invalid patent, okay? So this is the goal right here. Now, here's the problem. Okay, so this is the goal. I'm just removing the prior art for the sake of clarity, but now this is the problem, is you have a competitor, let's say competitor B, that has a patent that predates your product, and therefore necessarily predates your patent, okay? And that covers your product, okay? That is the problem. And we can remove your patent because that doesn't matter anymore, because regardless of whether you have that patent, you're still infringing competitor B's patent. I hope that's clear. And if it's not, I'll try to answer that question a bit later. And let me pause for a moment just to grab a drink of water. All right, All right, on to the next mistake. Number 5, I need to do a pre-filing search before applying for a patent. Okay, not necessarily. And this sort of ties into what I was just talking about. A lot of my clients come to me thinking that they need to do a search before they apply for a patent or even before they start marketing a product. The answer is you're never required to do a search, at least not under the law. There may be reasons to do it, but there are pros and cons. And ultimately, it comes down to a risk-benefit analysis, whether you do a search. Now, I want to be clear that there are really 2 different kinds of search we're talking about here. One is a patentability search, and the other is what we call freedom to operate search, or FTO search. Okay, we do them for completely different reasons, and they have completely different focus. So a patentability search is what it sounds like. It is a search of the prior art that enables you to make a judgment whether you're entitled to get a patent on your invention. Sometimes we do those. More often than not, we don't, because usually, in my opinion, and I think in the opinion of most of my colleagues, the benefit does not outweigh the cost. You could spend a whole lot of time and money doing a search and not find anything relevant, and it could end up getting published tomorrow, because most patent applications are held secret for a period of time in the patent office before they get published. So it may have been filed before your filing date, and therefore it's prior art, but it could get published the day after or a month after you do your search. So that's one reason. And also because of the fallibility of human searchers. You could search until you're blue in the face and not find something, doesn't mean it's not there. I think it's usually more beneficial to spend your money filing a patent application than doing the search. But that being said, there is no one-size-fits-all approach to this, and it really depends upon your specific situation, what your goals are, and how risk-averse you are. Okay, so that's patentability search. Now let's talk about freedom to operate, FTO searches. That deals with the colored circles I was showing you before, the red and green circles. That's about freedom to operate. Do you have the ability to market your products or services regardless of whether you can get a patent? That's irrelevant, okay? And this relates to, does a third party have a patent that may prevent you from making, using, selling, or importing your invention? So this kind of search, the way it's done is quite similar, but what we're analyzing is the claims of those third-party patents. And this kind of analysis tends to be much more expensive. A patentability analysis can be a couple $1,000s for a quick and dirty analysis, depending upon how thorough you want to be. A freedom to operate analysis can be well over $10,000, or sometimes multiple tens of thousands, depending upon a lot of factors like how crowded the field of technology is and how risk averse you are, how thorough you want to be in your search. Okay, so hopefully that's clear. All right, mistake number 6, thinking that patents are always the right form of IP protection for technology innovations. Not always. So, some of you may have heard the analogy of, to a person whose only tool is a hammer, everything looks like a nail. I don't want to be that guy. I don't think I am. So I'm a patent attorney, yes, but more importantly, I'm an IP attorney. And although patents are a powerful form of protecting technology and often what makes the most sense, it's not always. And actually, quite frequently, I advise clients not to pursue patent protection when they come to me for that purpose, for various reasons. And so, I'll tell you what those factors are, but I don't want people wasting money on the patent process if that's not going to benefit them or their company. So let's go over the major forms of IP first. So these are trade secret, copyright, and trademark. And patent and trade secret are kind of very closely related, and yet they are mutually exclusive. Okay, so for the exact same subject matter, you cannot get a patent on it and keep it a trade secret. And that's because when you get a patent, you actually have to disclose how to make and use the invention in your patent application, which will get published as the patent. Okay, so patent and trade secret, mutually exclusive for the exact same thing. But what I mean by that is you could have a product that has a patent on certain features, and the other features of that product you choose to keep trade secret. So you can have a combination of those forms of protection for any given product or service. Now, copyright and trademark, those are kind of orthogonal to these other forms. Those are overlapping forms of protection. You can have patent protection with copyright and with trademark. Copyright, as I explained before, protects expressions of ideas, software being an example in the text sphere, the written word, etc. Graphical user interface screens, protectable by copyright and by patent, actually. So, all right, those are the major forms of protection. So then how do we weigh, for example, whether to seek patent protection on a particular invention or give it or keep it as a trade secret? Well, some of the factors we would weigh are how easy or difficult is it to detect infringement? Or conversely, how easy or difficult would it be to reverse engineer your product? I mean, those are kind of like two sides of the same coin, right? So if it would be very difficult or expensive to detect infringement, then that kind of weighs against getting a patent, because if you don't know if somebody's infringing, then what good is your patent? Well, we talked about other reasons, right? To satisfy investors, right? So that might be one reason. So this is not a black or white question. This is just a factor you weigh among other things, okay? Another factor we would weigh is the expected life cycle of the invention, right? So if it's got fairly long life cycle, that might be one reason to seek a patent on it. If it's not going to be obsolete in 3 years, if it's going to be obsolete in 3 years, for example, you know, it could take you a year or two to get a patent at least. So questionable value there. The thing to keep in mind, though, about the life cycle of an innovation is you're not really talking about your implementation. You're talking about the life cycle of the invention as defined in a patent. Remember, a good patent attorney can expand the scope of the innovation much more broadly than your implementation. So your implementation might be obsolete in 3 years, but if your patent is claimed very broadly, then that might encompass all sorts of variations and extensions of your implementation for a number of years. Right? So that's a real beauty, or one of the beauties of patent protection. And another factor we consider in deciding whether to keep it as a trade secret or patent, it would be the strength of patentability. Is it the type of invention that's going to be easy to patent or difficult? Is it a technical solution to a technical problem? Or do you have, for example, a piece of software that is just implementing a business method? Those are all the things we weigh. All right, mistake number 7. Let me do a quick time check. All right, we're good on time. I've got 15 of these, by the way. All right, mistake number 7. I don't have time to think about patents right now because I'm trying to get my product out the door. I'm trying to raise funds, et cetera, et cetera. Okay, my response to that is you don't have time not to think about patents or other forms of IP protection early in the process, okay? Patents can be critical to getting funding, as I told you before, and they're very time sensitive. If you wait too long, you will not have the ability to get a patent because the prior art develops. Okay, so generally, you have to file a patent application before there's any public disclosure or sale of a patented invention. Okay, and that's not only by you as the inventor, but also anyone else in the world, right? So even though you may not be in a hurry to disclose or sell your invention to the public, you're operating in stealth mode. Somebody off, you know, somewhere else in the world is probably working on something similar. And tomorrow, maybe they file a patent application for it, and it doesn't even need to be exactly what you're doing. But if it's close enough to make your invention obvious, then that could prevent you from getting a patent. So you really need to be thinking about these things right from the beginning. It's never too early to actually start thinking about IP protection. Mistake number 8 is thinking that you're going to patent the general idea, but keep the details of how to do it, the secret sauce, as a trade secret. No, that's not going to work. And the reason is because patent has to disclose the invention with enabling detail. Okay, as I mentioned before, that's part of the bargain. Actually, think of a patent as a contract. It's a contract between the patent owner and the government. So the government is giving you a limited time monopoly, basically, on the invention. But in exchange for that, as part of the bargain, you have to teach the public how to make and use your invention. So you cannot patent the general idea without disclosing how to do it in your patent application, which becomes the patent. So that's why we do need to think quite carefully about the trade secret versus patenting right at the beginning of the process. All right, mistake number 9 is Joe didn't exactly contribute to the invention, but he was part of the team. So we need to list him as an inventor. I hear this all the time from my clients when I ask them, who are the inventors of this? Their initial answer, they want to name everyone on the team. You can't do that. So first of all, there is a very precise definition of who is an inventor under US law. And every country, by the way, has their own patent laws, and patents are country specific, right? But in most countries, it's the same with minor differences. And in the US and most countries, it's the person or people who conceived of the invention being claimed that are the inventors. Okay, it's not somebody who just implemented it. So, and for example, somebody who came up with the idea of, okay, we're going to have a software application that compresses video in a particular way that no one has thought of before. And they come up with the algorithm and they hand it off to somebody. That second person does nothing more than code the algorithm. Okay, that second person is not the inventor. It's the first person who came up with the idea, the algorithm, who's the inventor. Now, it is possible that the person who's coding it comes up with some modification or a particular implementation that you actually want to claim, that the first person or the company they're working for wants to actually claim, in which case, if you then claim that aspect of the code, they can then become an inventor, but only if they're claiming something that they conceived of. And multiple people can jointly conceive of something together. It's not necessary that every person conceived of the whole thing, but the key is conception and not just implementation. Okay, so just because somebody's on the team doesn't make them an inventor. Why does this matter? Because if you knowingly name someone as an inventor who should not be named as an inventor, that's a quick way to an invalid patent or an unenforceable patent. And that refers to naming people who shouldn't be named. It also refers to omitting people who should be named. So you need to be careful about that. All right, so sorry. Now, ties into the next mistake. 10A and 10B will relate to this, right? Thinking that, well, I'm the inventor, so I own the patent. Okay, so yes, the inventor or inventors own the patent by default under the law. Typically what happens, at least in the high-tech space and in most corporate scenarios, is the rights get transferred to the company or assigned to the company. An assignment is legal language for a transfer of rights, of ownership rights. So most companies require that their employees who invent for them assign their rights in any patents and any inventions to the company. That's what they hire the employees for. So that's typical, and that's, if you're starting a company, you want to make sure your employees actually sign an employee agreement where they are promising that they will assign all their rights to the company if they invent something. Now, what's the other side of it? Is thinking that, well, let's say you're an employee working for a company and you come up with something that's unrelated to the company on your spare time. So you think, well, I invented it while I worked for the company, and this guy Jordan told me that if I do that, I have to transfer it to the company. So I guess the company owns the patent. Not necessarily. Okay, so really, it does depend upon what you signed when you went to work for the company, if anything, and what that agreement says. But in general, most employment agreements would say that if you invent something that is related to the company's business, okay, if it's within the scope of the company's business, that you would need to assign to the company. But if it's outside the company's business, then you wouldn't. Likewise, if you are inventing something on company time or using company equipment, that may bring it under the scope of that obligation to assign it to the company. Again, this is almost always dependent upon an agreement, typically an employment agreement that you sign when you join the company. All right, mistake number 11, thinking that design patents are only for aesthetically pleasing designs. Well, what's a design patent? Let's talk about the types of patents, okay? The three main types of patents are utility patents, design patents, and plant patents, okay? Plant patents relate to plants, the things that you plant seeds in the ground and it grows from that. I don't deal with those. That's very specialized. Probably, I'm guessing most people on this webinar don't deal with those, so I'm not going to talk too much about those, okay? Utility patents are the most common, especially for protecting technology, and also for protecting pharmaceutical, life science inventions. Design patents protect visual features of something, of anything, okay? And the requirements for getting a design patent are more or less the same as utility patents, with a few subtle differences, but whatever you're trying to patent has to be novel, and it has to be non-obvious, like with a utility patent. But visual features, and it doesn't need to be nice visual features, doesn't have to be visually appealing, okay? It just has to be novel and not obvious. But the key is a design patent does not protect the functional features, only the visual aspects. On the other hand, a utility patent protects functional or structural features, okay? Well, so why are design patents important to think about? Well, so some typical things that you use design patents for, which may not seem that interesting to a lot of people on this call, we'll start with these, are like jewelry, furniture, the shape or form of a car or a car part, like the BMW grille, for example, musical instruments, a famous example being the Fender Stratocaster electric guitar, clothing, children's toys, those things can be subject of design patents. Adult toys, anything that has a visual feature potentially that's novel and non-obvious. But how does this relate to technology or startup companies? Well, computer technology in particular, for example, consumer devices like smartphone can be the subject of design patents. Apple's got lots of design patents on the iPhone and other products of theirs. Design patents can also be used to protect graphical user interface screens, as well as emojis and icons and animations, again, as long as they're novel and not obvious. So actually, and this is very often overlooked by technology companies, design patents can be a really powerful form, a complementary form of protection to utility patents. You can get both a utility patent and design patents, or potentially multiple patents, on the same product. Okay, so enough about that. 1 second pause here. Whoops. All right, mistake number 12 is I have a provisional patent. People say this all the time. Sometimes they say it just as kind of shorthand, but sometimes they actually mean this. Why is this a mistake? Because there is no such thing as a provisional patent. There is only a provisional patent application. A provisional patent application will never become a patent. This is the really important thing to understand, okay? By the way, and provisional patent applications only apply to utility patents, okay? So provisional patent application is a placeholder. It lives for 1 year. And what it does is it gets you a filing date. Remember how I told you that filing a patent application early is critical to preserving your rights, okay? And so a provisional patent application is basically a placeholder that gets you that filing date. They stake in the ground, and you must then follow up with a non-provisional patent application within 1 year if you want to get the benefit of that provisional filing date. If you fail to do that within 1 year, the provisional patent application just dies. You can refile it, but then you've let 1 year go by where prior art has developed. So you can still, potentially get a patent, but your likelihood may be reduced because you've waited a year longer. Okay, so that's provisional patent applications. Now, next mistake people make related to provisional patent applications is thinking that you can use your pitch deck as a provisional patent application, the pitch deck that you use to try to get investment funds. And my response to that is, how about no? Okay, sorry, not too many more of these GIFs, but I try to lighten it up a little bit. Now, the thing is, there's no law against using your using your pitch deck as a provisional patent application. There's no regulation that says you can't do it. It's just foolish, because I have, in the course of my career, almost never seen a pitch deck that has enough detail in it to be sufficient as a patent application. The really important thing to keep in mind here is a provisional patent application has to have the same level of detail in it as a non-provisional. The reason a provisional application is advantageous sometimes is because the format can be, the format requirements are very loose compared to a non-provisional patent application. And by the way, non-provisional patent application is basically, you can just say a normal patent application. That's the one that will get examined by the patent office, and that can turn into a patent, okay? So non-provisional patent application is like the normal or regular patent application. Provisional is just the one that sits there for a year, then dies, okay? But you have to put the same amount of detail in a provisional as you put into a non-provisional, which is enough detail to enable a person of ordinary skill in the relevant field to make and use the invention without undue experimentation. Now, that's a mouthful, I know. It's enough detail to enable a person of ordinary skill in the relevant field to make and use the invention without undue experimentation. Well, what's undue experimentation? We don't know until you go to court after you get a patent and the person you're suing says you don't have enough detail in there. That's when you find out. So what we try to do is be conservative and put in enough detail. And a pitch deck almost never has that level of detail. All right, mistake number 14. Let me check the time here. 41, okay, we're doing well. Patents are irrelevant if I'm going to open source my code, okay? Not necessarily true. Even if you're open sourcing your code, you may still want to try to patent it. The thing to keep in mind is an open source license applies to the code, whereas a patent applies to the invention. And remember, an invention can be defined much more broadly than the code itself. Many open source licenses, and keep in mind, there are many open source licenses out there, and how patents are impacted by them, if at all, really depends upon the specific license you're talking about. And I do not have time in this webinar to go into the specifics of any particular open source license in that regard. Okay, but so many open source licenses actually require applicable patents to be licensed, but then how they define what patents are applicable can vary. Right? And so why might you want to get patents anyway, even if you're open sourcing? Well, you may want to use the patents against the third party who's implementing the invention, the broadly defined invention, but not the licensed code. You also might want to distribute a non-open source version of your code, which you could patent. You may want to use your patents against someone who breaches the open source license. So remember, an open source license is just a contract. People can breach a contract. And if they do, in the absence of any other protection, your only remedy for someone breaching a contract is a contract-based lawsuit where the damages you could potentially recover are not necessarily as much as you could require for, say, patent infringement, and the degree of proof required may be higher. And finally, you may want patents for defensive purposes, even though you're open sourcing the code, like I mentioned earlier in the webinar, to deter aggressive moves by other operating companies that have their patents. All right, last one. So mistake number 15. Okay, I've been talking lots about patents, a little bit about trade secrets and copyright. Trademarks. A trademark is an identifier of the source of goods or services, tells the consumer who's producing this product or service, okay? Now, the mistake people make is thinking that a trademark should describe the relevant goods or services. And this is often a debate I see between the marketing department of a company and the legal department or their outside lawyers, right? Is marketing people often want the trademark to be very descriptive of the goods or the services because they want the consumers to know exactly what their product is. But that's not necessarily a good thing to have a strong trademark. You have different levels of strength of trademark protection, okay? And so the least protectable thing is something that's generic, which is, you can't get trademark protection for a generic mark, like the word computer or the word sunscreen, okay? Or aspirin, which, by the way, used to actually be a proprietary mark when it first came out, but aspirin has become generic. Other examples of generic marks, which used to be proprietary but became generic: laundromat, escalator, flip phone. Okay, can't protect generic marks. The next level up is descriptive marks. Can be protected. Like, for example, what's a descriptive mark? Cold and creamy ice cream, or best pizza. You have to show over a period of years that the consumers have associated that name with you as the trademark owner in order to protect a descriptive mark, which is why it's not a very strong mark. So then the next level up, the third one out of 4, is suggestive marks. Those are what we call inherently protectable, strong marks. Examples of suggestive marks, they don't describe the goods or services, but they suggest them, are Jaguar for cars, okay, or Airbus for planes, Netflix for streaming services, okay, suggestive but not descriptive. They're stronger marks. And the strongest form of protection of all, the fourth, is what we call arbitrary or fanciful marks, which from the name, from the mark, really gives the consumer no idea at all what the goods or services are. Examples being Kodak for film products, Exxon for gasoline, Apple for computer products or communication products. Okay, those are the strongest kinds of marks. That's, from a legal standpoint, what you would prefer. And understanding that marketing people like descriptive marks, we just have to try to strike the best balance we can. Okay, so those are all the mistakes that I was going to talk about today. I will go into Q&A in a moment. Here's my contact information. Really, the best way to contact me initially is through LinkedIn. If you have any follow-up questions, I generally do give one free 30-minute consultation on IP issues. And so if you would like to reach out to me, feel free. The slides will be made available to anyone who signed up with their email address, which I think is probably everyone on the webinar. That'll probably come out in the next day or two. You should receive those by email. And if you get a chance, check out my podcast, The Tech Law Hangout, which talks about the overlap between law and technology. There's a bit about patent law, but also other areas like privacy law, trade secret law, other aspects of IP, space law. So anyway, with that being said, I'm going to keep this displayed, and I will go to Q&A, see if there is anything. Right, okay. So give me a moment to just peruse these. We got a few questions here, and I'm going to take a drink. What should an online course creator be needing to protect his created work and information on his website? Also, is there an infringement involved if one does online book clubs where he creates quizzes and coaching material related to well-known books? Thank you. Okay, what should an online course creator be needing to protect his created work? Okay, so anything you create, any original work, the term in copyright is work of authorship or just a work. So any original work you create is automatically protected by copyright as soon as you fix it in a tangible medium. And so that could mean storing it in any non-volatile memory, storing it on a hard disk. As soon as you do that, it's protected by copyright. Now, you may want to register whatever material that you're putting out there. It's not required to have copyright protection. Registration is not required. It is beneficial and required if you want to sue somebody for copyright infringement. And also to get certain damages under the copyright statute, you have to first register. But in general, my advice and really I'd have to know the specifics of your situation to give you any advice on this. I'm not giving legal advice, but I'd say most of the time, it doesn't really make sense to register something under the Copyright Act until you're getting ready to sue somebody. And so let's see, is there an infringement involved if one does online book clubs where he creates quizzes, coaching material related to well-known books? The short answer to that question is if you're using well-known books and materials and creating other material from that, then possibly, yes, you possibly could be infringing other people's copyrights. The question is whether you'd be making a derivative work. And so, again, impossible to answer a blanket answer. It just depends on exactly what you're doing. But you want to be careful about that. And the safest thing really is to get the permission from the copyright owners of those materials, from those well-known books before you do something like that. Let's see, next question. Is it an infringement to use a Gen AI generated image created for animations for commercial purposes, e.g. prompting in Pixar or other style? Well, so the answer is it depends. So what we know now, and the law is just developing in terms of Gen AI, generative AI, hopefully everybody knows what this is, right? Like Midjourney is an example of image-based Gen AI, or ChatGPT for text-based stuff. A lot of other examples out there. So if you're using a Gen AI generated image created for animations for commercial purposes, so there's no copyright protection for something that is generated by Gen AI. So if the Gen AI creates something from scratch, then the Gen AI can't own copyright in that. We know that. The question, though, is whatever it's spitting out something that was created by someone else, right? Because potentially it's taking something. I mean, obviously it's trained. The LLM is trained on, the model, I should say, is trained on something that already exists. And so if it's spitting that out in only a slightly modified form or just with things added to it, then potentially if you're using that commercially, you're using something that somebody else copyrighted before the model actually generated something with it. So answer, as often is the case, is it depends, but potentially you could be infringing by doing that. Okay. Jennifer asks, I asked a former teammate to sign off on an assignment for a provisional application from last January. They didn't do it. no response or further dialogue, but still talk to the team regularly about other products we do together. What is likely to occur? Sorry, Jennifer, I'm not sure I understand what you're asking in terms of what is likely to occur. You asked them to sign off on an assignment for provisional, right? So then if they were the sole inventor, then by default, they remain the sole inventor. And if they were a joint inventor, then they didn't sign off on it, but everybody else did sign their rights to the company, then that person who didn't sign off still has a joint interest in ownership. So what's likely to occur? It really depends on your relationship with that person. I mean, they may never do anything about it. I mean, you can still apply for a patent, but there's now potentially a cloud on the title. In other words, the ownership is unclear. And so it's really best to get that clarified. Investors may ask questions about the chain of title before giving you money. So it's probably going to be important to clear that up. Josh asks, I got a patent. How can I know that no one will use the technology that wrote there by himself or copy it or change one word or use it by themselves? Okay, I got a patent. How can I know that no one will use the technique that is in the patent, I think is the question. Or how do you know they're not going to change it a little bit? Well, I mean, there's no easy answer to that question. How do you know if somebody's infringing your patent? And that's why I said in the beginning, if it's going to be very difficult or very expensive to detect infringement, then that is a factor that weighs against trying to patent it. But there are other factors that you have to weigh. You mash them all together and you talk about it with your patent attorney and you come up with a decision. That's one factor. And the easy answer is you may not know, but it depends on what kind of invention is it, right? I mean, if it's something that appears on a graphical user interface on a computer, it might be pretty easy. But if it's code running on a back-end server, you may or may not be able to tell. No easy answer to that. Okay, Mr. or Ms. Anonymous asks, what is a process patent? How difficult are they to acquire? The answer to that is there's no such thing as a process patent per se. Process patent is just kind of like a slang that, I mean, any process that you invent can be patented, and that would usually be patented with a utility patent. And we would use what we call method claims typically to patent a process. Although if it is a computer implemented process, we would also have device claims and system claims. So there's really no such thing as a process patent per se. I think people just use that to refer to a patent you get on some process you invented, but it's not a term in the law. Okay? You can't look under the patent statute and find process patent per se. You can patent a process, but there's not a process patent. You shouldn't worry too much about these categories, really, because we're mostly dealing with utility patents, and to a lesser extent, we're dealing with design patents. Design patents aren't usually going to apply to a process, except an animation process potentially could apply to. But for the most part, in technology, a process is going to be a utility patent. And let your patent attorney worry about how to categorize it. How difficult are they to acquire? No more difficult or no less difficult than any other kind of patent. As long as it's novel and non-obvious and meets the eligibility requirements, you can get a patent on it. Okay. Doug asks, is there anything special about AI applications? There's a lot of work being done in this area by large companies, so we could be stepping into someone's patent. Let me pause for a drink. Yes, indeed. There's a lot of work being done in AI, and I'm doing a lot of the patenting of that work. And actually, I've been patenting AI inventions for decades. Some people think that this is a new phenomenon, AI, and that's because of ChatGPT and other forms of Gen AI becoming popular starting a couple of years ago. But AI has been around for decades, particularly discriminative AI. And I've been working on that and Gen AI for a long time. So is there anything special about them? No. they're just, in terms of IP protection, there's nothing special about AI applications. I would say there are certain kinds of AI that are easier to protect than others from an IP standpoint. If you are actually improving the AI itself, for example, you've come up with a new way of training the model, maybe a different way of assigning weights and parameters that is more effective. That is a technical solution to a technical problem, and so that's likely to be more protectable under the IP laws, particularly patent. On the other hand, if you're taking AI using kind of an off-the-shelf machine learning algorithm and applying it to a human problem, but just doing it more efficiently, it's AI doing it, that's going to be harder to protect. And again, I mentioned if you're trying to protect something created by the AI itself, spit out by the AI, that's not going to work, at least under the present law. But generally, nothing special about AI from an IP standpoint. It's just another type of technology. Same requirements apply. And yeah, if you're inventing in that area, if you want to start a company in that area, you may be stepping on someone's patent, but frankly, you're probably going to be stepping on someone's patent no matter what area you're innovating in, whether any form of technology or pharma. I mean, you're almost always going to be stepping on somebody's rights. But the real question is, will they know about you, number one? Number two, will they care? And number three, will they have the ability to do anything about it? And so, I mean, there's a lot of hurdles that have to be crossed before you worry about someone else's patent. So I wouldn't let that stop me from entering a field just because I might be stepping on somebody's toes. But again, this is very case specific. Can't give any advice about this without knowing the facts. Okay, so next question. If the problem has already been explored through publication with results and someone from another country files a patent, how does that work? If the problem has already been explored through publication with results and someone in another country files a patent, how does that work? Okay, so most countries' patent laws look at the prior art anywhere in the world. I can't tell you for sure that some country may not do that way, but every country I'm aware of does it that way. So if, for example, you're applying for a patent in the US, but somebody published exactly your invention or very similar in Japan, in Japanese, a year before you filed your patent application, that's going to be a problem for you. Okay, it doesn't matter what language it was in, it's what is the content. Okay, and it works usually the same way in other countries. If you're trying to patent it somewhere in Europe, but you published it in the US before, or somebody published it in the US before the filing of the patent application, that's going to be a problem. But it also comes down to, is the patent office in the country in question going to be aware of that publication? In the US, the patent applicant has an obligation to disclose any prior art that's relevant that they're aware of. You don't have to search for it, but if you're aware of it, you have to disclose it to the patent office. Some other countries have that requirement, not all. So again, another answer where it depends on the situation. Okay, another question from the same person. As you mentioned, the pitch deck cannot be considered as the patents filing solely from the IP. Usually, there's no law that says you can't use a pitch deck, but I'm saying that almost every pitch deck I've ever seen is not adequate to be a patent application. Okay, but the question says, in my previous company, they used mostly pitch decks for filing the IPs in collaboration with university partners. Question, if I did it for the first time and the university partners proved it, does it make them to be the inventor? Please suggest. If you did it for the first time and the university partners proved it, does it make them the inventor? Not necessarily, because remember, the inventor is the person who conceived of, or people who jointly conceived of the invention, who thought of the idea, okay? Not the people who proved that it works or implemented it. But here's where you have to be careful. What are you defining as the invention in the patent, okay? A patent has multiple claims, typically. So you may have a claim to the broad idea, but if the patent includes a claim to some aspect of the implementation, then somebody who thought of that aspect of the implementation then becomes an inventor. So again, this is not something you should decide on your own. You really should be talking to an attorney about how you define inventorship and who came up with what part of the invention. I realize a lot of these answers are kind of ambiguous. That's the nature of the law. It's almost never black and white. And you really have to drill down into the facts to know the answer. Okay, I don't have any more questions here. And looking at the time, it's 10:03. I will give it maybe another minute and see if another question pops up. If not, then I guess we will call it a webinar. And I really appreciate everyone attending. Somebody asked, how much do I charge? This is not something I talk about on webinars. I'd be happy to chat with you about that one-to-one. Ciara says, thank you. You are welcome. Thank you all for attending. I appreciate it. I really hope this was helpful. Hard to know sometimes if the level of detail I'm getting into is too low or too high or just right. Again, happy to entertain questions later one-on-one. All right, so that being said, I am going to end the webinar now, so it seems like there aren't any more questions. Thank you all so much for attending. Take care and goodbye.